I will now call CCR number 1390 in re Meghan Rogers.
Good morning, Todd Thompson appearing as Special Disciplinary Counsel for the Board of Examiners of Court Reporters in this matter involving reporter Meghan Rogers. This matter involves a failure to timely deliver a transcript for an appeal that involved the severance of parental rights. There were repeated failures. The complaint was filed. There was no response to the complaint. And at the hearing on this matter, the respondent did not contest any of the alleged facts and did not, as the board noted, present any evidence justifying the delay. The board found a violation of Rule 9.F2 for professional incompetency. There was also an allegation of a violation of 9F3 for misleading or untrue representations by the reporter. And there was no comment one way or the other in the board's report. The board
didn't find her that she had violated any rule except for competency, correct?
Correct.
So the fact that there was no response filed, there was some confusion about that, wasn't there, as to whether she where the response would have gone or whether she received it and when she received it? Wasn't there some confusion about that?
Not that I'm aware of. There was no confusion at the hearing in terms of her admitting all of the factual allegations.
Well, I'm not talking about the formal complaint. I'm talking about the original investigation, which apparently led to because she filed a response after less than a month after the formal complaint was filed, correct?
Not within the 20-day period, no.
But
You're talking about the original complaint or the formal?
The formal complaint.
Yes, she did file a response to the formal complaint.
And the original complaint, there was some confusion over whether she received notice of that or when she received it and whether she responded, because she testified that she responded to that, didn't she?
She did not testify that she responded to the original complaint.
On a piece of notebook paper that was possibly sent to Ms. Raymond or to someone else?
There was no evidence at the hearing on the formal complaint to that effect.
But she wasn't found to have been in violation by failing to cooperate with the investigation.
Correct.
Thank you.
And there was also no finding of a violation of 9F3 about making misleading or untrue statements. There was not a finding either way. There was no mention of that in the board's report. The board recommended.
What does that mean there's no finding either way?
I'm sorry?
What does that mean, no finding either way? I mean, are you here asking us to consider that allegation?
Yes, I am, as I did in my brief.
But you have
on what basis? Sorry. On what basis? Again, I think I anticipate Justice Wilson's question. If the burden of proof is on you and it was not carried because there was not a finding of a violation, how do we consider it?
The facts that were admitted indicate that the transcript was allegedly completed to the degree of 85% by the 1st of September, and that only 15% remained to be done. And yet it was not turned in until February of the next year.
Yeah, I guess I'm not asking about the substance, but just the procedure.
So I think what the question is that you charged 4 violations in the complaint. And then at the conclusion of the formal hearing, the board only found 1 violation. And so, did you file any exceptions to the board's lack of finding of violations below? How would those other 3 violations be before us?
Because the board makes a recommendation and the facts are before you. So you can apply the facts and the allegations of the formal complaint in determining the proper discipline in this matter. So all of the information that you would need is before you, and you are the body that ultimately determines that issue. The board does not ultimately determine that issue. Board makes a recommendation.
Based on its findings of rule violations.
Based upon its findings. And its findings are that all of the facts were admitted and that no evidence was presented justifying the delay.
Right, but you charged her with making misleading, deceptive.
I did, and I proved facts which I believe absolutely prove that she made misleading representations to the court in claiming that this transcript was 85% complete by the first part of September.
So the problem is just you don't have the fact finders, the lower tribunal agreeing with that. You don't have a finding.
We do
of a
have the
violation.
facts. We have all of the
But you don't
facts.
have a finding of a violation. You don't have a conviction. Just, I know we don't speak in terms of convictions, but that's what you don't have.
You are correct, but they don't make convictions. They make recommendations.
Well, they make recommendations with respect to.
Make
It's the-
findings about violations.
But they do make, right, I mean, is that wrong from your perspective?
It is my opinion that they look at the facts and that they make recommendations based upon their
As to-
interpretation of the fact.
As to both rule violations and recommended discipline.
Correct.
Okay, let's talk about that then in the context of the rule violation. She testified that she thought she was 85% complete with the transcript in September, correct?
Correct. Well, she
And-
didn't, she actually put that in her motions.
And you didn't present any evidence to refute that, correct?
I would disagree. We presented evidence that it was not completed until February of the next year.
But you didn't present any evidence to refute the 85% estimate, correct?
No,
And
other than the fact that it didn't get done in September, it didn't get done in October, it didn't get done in November, it didn't get done in December, it didn't get done in January. That extra 15% didn't get done until February.
And she testified that her computer crashed. Is that correct?
I believe that she had a number of excuses, yes.
And
Said
did
she
you,
changed
did you,
jobs?
did you present any evidence to refute that her computer crashed?
I did not.
She also was working with Best Buy for that, correct?
We don't know.
Did she testify to that?
She did.
And did you present any evidence to refute that?
Other than the timeframes, no.
I didn't see in the transcript any evidence that there was a criticism of the transcript that was presented.
That's correct. It was accepted and used. But the competency issue had nothing to do with the ultimate transcript. It was the timing issue.
So it was only the time issue that you're alleging it was late and that it shouldn't have been late.
Correct.
She changed jobs also.
Not until September or October, according to her own statement.
And was there some testimony that it was more difficult for her to get information from Shawnee County because of the change of job?
Sort of.
There any, as I read the transcript, I saw no testimony to refute that, correct?
I saw no testimony that I would call solid testimony that explained that and how that was an exceptional circumstance, which was her duty under the rules and under the court's order, was in asking for extension, she was to state and explain the exceptional circumstances. And her statement about Shawnee County didn't have any meat on the bones.
But the Court of Appeals was satisfied that she should have those extensions to the extent of granting it until October 22nd. Is that correct?
They extended a number of times with the caveat or the express direction that there shall be no more extensions. And then they gave another extension and another and another. The first few were with, except for exceptional circumstances, the last several extensions did not even include that option, the exceptional circumstances. They said there will be no more exception or extensions, period. And those directives were still not met.
Is there any evidence presented as to what a different court reporter would have done given the difficulties that she presented?
Other than the board, as you know, has panel members who are court reporters and
they questioned her also. But
correct.
my question is whether there was any evidence presented by a different certified court reporter as to what they would have done given the difficulties that Meghan Rogers had in completing the record.
We did not engage an expert witness to review the facts and opine on that because frankly, there's no hypothetical information there of such a solid nature that an expert could opine. The mere statement that I changed jobs and I had computer problems and went to Best Buy, in my opinion, did not warrant hiring an expert witness to opine on that.
Did they warrant a finding of mitigating circumstance?
There is no finding of mitigating circumstances.
I'm asking whether you submitted, whether that should be considered as a mitigating circumstance.
Whether what should be considered.
The computer crash, any difficulties she may have had in getting information from Shawnee County because she had a different job. Apparently she testified as needing emergency surgery and also having her children home because of COVID and obtaining COVID herself.
She made those allegations. I did not, frankly, contest the fact that she was at home, the fact that she changed jobs.
So you would have considered that to be her job to present those as mitigating factors?
Yes, I think so. I have no time left. Does anyone have any additional questions?
You'd like to make a recommendation to the court?
I have recommended in my brief that the court accept the recommendation of the 6-month suspension that was made by the board after it heard all of the evidence. And I would note that that's a couple of months shorter than the amount of time that this family had to wait to get this transcript, and the transcript being 8 months, delivered 8 months after it was originally due. So acceptance of the board seems very reasonable to me.
there any presentation of damages that may have been in cause of the delay,
In terms of
the hearing?
at the hearing,
Yes,
there was no evidence other than the fact that a 6-year-old and two of his
that presented at the hearing.
that this involved 3 children and their mother and the severance of parental rights. Yes.
In the transcript
In the transcript of the hearing,
of the hearing below in this case, was the underlying case mentioned?
I do not recall. Anything else?
Questions from anyone? Thank you.
Morning, Chief Justice Lukert, Justices of the Supreme Court, Brian Smith, appearing on behalf of Meghan Rogers, and Ms. Rogers is here to my right. First of all, Ms. Rogers would like you to know that she has been honored to be a part of the profession as a court reporter, wants to remain as a court reporter, Kansas. And there was a delay in the filing of this transcript. It was certainly due to extenuating circumstances that have been presented in the record. I do want to touch on Justice Wilson's first questions about the testimony of the first letter that was given about a complaint. There is, in fact, testimony in the transcript provided to the court on pages 16 and 17 of the transcript. Question: now you received a letter from the board advising you the complaint had been filed sometime either in real late 2020 or early 2021, correct? And the answer was, I believe so. I'm on page 17 now. And the letter asked you to submit a written response within 30 days, correct? And the answer was, of which I did. Question: can you tell the board how that response was allegedly sent? Answer: I hand wrote a response the first time and mailed it back. I never received anything back, but I had to handwrite it as we were there in quarantine the last of January, right after my emergency surgery at the end of December. So her testimony was that she had responded to the original letter complaint. She also filed a response to the formal complaint. This case takes place in the backdrop, justices, of the COVID emergency. And I would ask the justices to think back to Administrative Order 2020 PR 16 issued by Chief Justice Lukert, which found that in order to determine, it says, as Chief Justice of the Kansas Supreme Court in consultation with members of the Kansas Supreme Court, I've determined the following actions are necessary to secure the health and safety of the court, users, staff, and judicial officers. And basically there were several orders. And the last one that strikes out to me is, other than jury trials in progress, all district and appellate courts, administrative offices, the offices of the clerks of the district court and appellate courts, and court services officers will be restricted to emergency operations until further order of the court. Now, it went on to provide that one of the items that was an emergency operation was any other appeal, motion, or original action requiring expeditious resolution. This case was on appeal, and my client did in fact file a number of requests for extension of time, all of which were granted. So the argument that somehow my client is incompetent because she requested additional time that were requested that
How
were
many
granted by the board.
requests for extension did she file?
There was 5. The
5?
last one allowed for a response on October 22 of 2020, which she did not file it by that date, which triggered the show cause.
June, August,
September.
September.
That's 4, and that was the last one. And then the 5th is the order where the court says, please.
No, then she filed an out of time motion in September because she didn't even make the,
Right, granted.
okay, and then the complaint was filed. Okay, so she filed 5. So just, this is not in the record, but based on my experience as a Court of Appeal judge who worked on the motions panel, arguing that the motions were granted, they're always granted. That they get 10,000 motions a year. So that's, they grant the motions. What are they going to do? Deny it? I mean, it's not going to make it any more ready. The only leverage that a motions panel has is to report, to discipline. I mean, you just don't have any leverage when a court reporter keeps asking and asking. So I'm just saying that that's not a good argument. So I'm not persuaded by this. And this is, to me, this is very troubling because it is. This is an expedited case. I don't know what else she had going, I did not read the transcript. So, but I don't know what else she had going on, but an expedited case for us, even when we have an expedited case, everything goes to the side because that's what expedited means. This is a termination of parental rights. Every day that a kid spends out of home counts. So this is a 5 or 6 month delay, maybe even longer, of getting these transcripts. And, she, I asked opposing counsel, she's saying very general things. Number one, she says in one, I'm finalizing. And then the next one, she says, I'm 85% of the way done. What does that mean? I'm finalizing and I'm 85% of the way done. And then another one just says, due to personal circumstances. No, she says to finalize edits. So she doesn't even say to finalize, like, I want to do the other 15%. She says to finalize edits, which clearly implies I'm done just editing. I think this is really troubling. And part of it is, I'm going to tell you, based on my experience of, you're down there and you're getting these, rote motions that they're just filing. And it's particularly troubling in expedited cases. So I would like you to continue with your argument, but know that I'm troubled by this. And I do want to hear what you have to say.
Yes, Justice Stanbridge, and you point out a great structural issue that exists within the court system as it relates. Part of the evidence in this case is my client left employment with the Shawnee County District Court and took up employment in the Douglas County District Court. The day you leave as an employee of the Shawnee County District Court, your passwords are canceled, your email, your e-filing is all canceled for that particular court. When you take employment in a different district court, you then that all has to be reinitiated. This occurred during the middle of the COVID shutdown.
When did she transfer employment?
September of 2020.
Okay, so this is how late, what in September of 2020 is when she filed her 5th
Correct.
motion for extension.
Right. So they were out of the office, generally working remote from March of 2020. They returned in July of 2020. She worked at that time for Judge Anderson, who was being appointed as chief judge, and they were moving chambers, as typically takes place in Shawnee County. So her records were boxed up, and she was moving. Then once they moved in July, then she changed employment in September and went to a different district. She did testify in this case that her computer did go down. She offered to the hearing board, the disciplinary board for the court reporters, to provide the best buy receipts and evidence, of what she had to repair. She ended up having to buy a whole new computer. That the transcript that was being worked on her computer, she had to start basically back over. I also note that she estimates that the transcript was 600 pages long. It ended up being 651 pages long transcript. This was a pretty substantial transcript. And one other response to you, Justice, that I think is answering the question of what power do you have other than to grant the motions? You know what the Court of Appeals had the power to do? The same power that every other court has in the state of Kansas to issue a show cause order, which is what the Court of Appeals did. And what they indicated was if you don't file the transcript by February 8 of 2021, you need to appear and show cause why you shouldn't be held in contempt. This transcript was filed on February 5 of 2021. So she was able to get it filed. 85%
Can you
estimate.
tell, I'm
Yes.
sorry, I don't mean
No,
to
no.
cut off your responses to Justice Standridge. But I had a question about our rule interpretation, professional incompetency. Is that a simple negligence standard, or what does that mean? Have we had an opportunity to interpret the meaning of that term?
Well, you have to pull from attorney discipline cases. There's not very many court reporter discipline cases. And the one case cited by Mr. Thompson was one involving the failure to respond to a motion for summary judgment. Ultimately, my client did respond and file what was requested. And ultimately, it was before the deadline for
Under threat of a show cause order and discipline. That's what it
Well,
took.
the show cause order is not necessarily discipline as a court reporter. It means the court may sanction
Same difference.
a person or a litigant. And it
Under
also-
threat of sanction.
It also provides that the court shall hear the matter, I'm just reading from KSA 620-1204A. One of the caveats says the court shall hear the matter at the time specified in the order, and upon proper showing may extend the time so as to give the accused a reasonable opportunity to purge oneself of the contempt. So there's even, it's allowed within the indirect contempt procedure that the court, even at that point, can give someone more time within the discretion of the court. Our suggestion in our brief is that requesting additional time and that's granted is not a sign of incompetence.
So so I get it straight in my
Yes.
mind, to summarize your position here before us today is, one, the transcript was not filed late,
Ultimately, it met the last deadline that was set.
not late.
Right.
And two, you're asking us to find no rule violation.
Well, we could have done a better job. Bottom line, my client could have done a better job. Now, mind you, this is in the midst of a pandemic with a lot of moving parts.
Okay,
'Cause
but just to cut to the bottom line, are you asking that this court determine that there was no rule violation, or are you conceding a rule violation?
we would ask the court, we suggested that they did not meet their burden in our brief of finding.
That's what I read. I just
That's
kind of wanted
correct.
to nail
Yes.
it down if that's what your position
That's correct.
still is.
That no finding, and particularly no finding of rule 9F3.
Well, no, I'm focused on 9F2.
Yes,
Which
that
is
is
what
nine
they
F two,
did.
because Mr. Thompson was the prosecutor. He's not a member of the board. And he was not one of the parties that voted on the finding. And the only finding was one of incompetency. And
Which
in
you
our,
disagree with.
correct.
Right.
And then our next request is if the court's going to find incompetency, that what the court does is admonish her. That she could have done a better job. And next time, let's do a better job.
And I guess
And-
my question earlier is,
Yes, Justice.
we could have done better. It sounds like is not your definition of professional incompetence, but is it a simple negligence standard? Like,
Competence?
did the respondent deviate from a professional standard of care? Is that enough? If the answer is yes, is that enough to support an F2 violation?
See, I don't.
Or does it require something more? That's what I'm
Require
trying to
something
understand.
more. That's why the court has rules that allow for an order of contempt to be issued, and then the court, within the court's powers, either can find contempt or in fact give the person additional time to correct whatever error they have. And what your honors do not have, and before you don't have anything that suggests that the case that was on appeal was decided differently because of the delay. There's no information that the transcript was not acceptable, meaning it was acceptable, meaning it was of sufficient quality and in nature that it could be utilized by the Court of Appeals. We don't even have before your honors any testimony about that the outcome was changed. If the
Well,
court's
under-
upheld,
I'm sorry. I
no,
don't
no,
mean to-
please, Justice.
Underlying facts supporting any conclusion of incompetence must be proved by clear and convincing evidence,
Right.
correct? So was there, to Justice Standridge's point, she was still employed by Shawnee County until September.
Yes.
And presumably had access to her records at least until she changed employment or until her computer crashed. And so until such time as it became difficult for her to access her records, is there clear and convincing evidence of incompetence? Or
I don't believe so.
to support incompetence?
was
What
back to
evidence is
Justice's-
there?
Justice Wall's question, what's the definition? And they have to have standard of evidence of clear and convincing.
Well, was there evidence presented to show that she should have done a better job when between April of the hearing and I believe it was pronounced to be expedited in May or May of 2020, correct me if I'm wrong. So between May and when the records were not accessible to her, there evidence of what, I mean, how along the something that could support the finding that she should have done a better job. I mean, what do we have?
You have the testimony of my client, her answers to the questions of Mr. Thompson and the board. You have there's not even a point in where any part of the transcript was talked about in the hearing that said, well, on page 64 of the transcript of the underlying hearing, it's gibberish. You've seen that. Yeah, I mean, we've all tried to read court reporter records. We all date back to the date when it came on a strip of paper and the court reporter could pull up the phonetics and none of us could read it, but they could read it. She does this where they speak into it. And so it transcribes it while she's talking into it. But again, it's kind of gibberish that she understands, but you and I wouldn't be able to understand it till it's typed and reviewed. And there's no evidence was presented at the underlying court or the underlying hearing of when did she access the file. They should have that evidence. There's a specific rule, and I cite it in our brief, of exactly what's supposed to be retained by the clerk of the district court of records of hearings. And it's supposed to be an electronic format. It's supposed to be the exhibits. I mean, it's all there. And then in its native form, which is going to be the recording, the verbal recording, along with the voice interpretation by a software program that she ultimately has to clean up and make it make sense to all of us.
But just, can you clear a factual situation? I'm reading from the board's findings.
Yes.
So, she files this out of time motion for extension of time on September 28th. That's granted, and she has until October 22nd.
Right.
Okay, but she doesn't file it until February?
So nothing is filed after after October 22nd. She doesn't file a motion. Doesn't file the transcript. Then the Court of Appeals enters an order in January, show cause order, that says you need to produce the transcript by February 8, 2021, or show cause why you shouldn't.
Right, but if the last extension granted to her was October 22nd.
Right.
Then she's in violation from October 22nd on. I mean, the show cause order doesn't count as an extension.
Didn't suggest it did. What I suggested was there's a process to find someone in contempt if they don't adhere.
Right, but you said, requesting additional time is not a rule violation. You said it was never late. You said it was not late.
Right.
It was late.
Ultimately, she complied with the last order of the court in this
Right.
case.
Well, no, but she filed it. The last extension that was granted was October 22nd. So October to November to December to January. I mean, she was 4 months late without asking for any extension of time. True?
Was after October 22nd, there was no further order on the
No
deadline
request,
until
no order. She drops off yeah.
Correct. And
Okay.
in her transcript is the testimony of what was going on medically with her. She had an emergency surgery after Thanksgiving and in fact, she testified she was even in quarantine for exposure to COVID when she finished this transcript and brought it over and delivered it.
But October 22nd to Thanksgiving is still a month.
651 page transcript, yes.
Is there any evidence presented as to how long this transcript should have taken to produce by an average court reporter.
Thank you for answering all my questions.
I am completely out of time and overtime. I have no further comments unless any of the justices have a question. Thank you.
Okay,
We would
thank you.
request that you first make a finding that there was no rule violation. And if you are going to find that there is a rule violation, that the correct discipline would be an admonition, not the 6 month suspension, and certainly not the additional 2 months that council has asked for. If you read the brief, the last paragraph says you should add 2 more months onto the discipline recommended by the board. We would suggest that you disregard that as well. Thank you.
Several of the motions for additional time were tardy, were out of time. This was supposed to have been turned in at the beginning of June. The transcript was. It wasn't turned in June. It wasn't turned in July. It wasn't turned in August. It wasn't turned in September. And in none of those months, is there any testimony of any mitigating circumstance like a change of job or illness?
Was there evidence regarding the standard of care in terms of the timing of preparing or producing a transcript of this 600 whatever pages in the record?
There was not. Again, an expert witness brought in, and part of the reason for that is because several members of the board are court reporters. I would quote this court, that quote, "Repeated failure to timely respond is clear evidence of incompetence." That's from the Dennis case. I would also note that while at the hearing, there was a suggestion that perhaps Best Buy documentation could be presented at some future date. It was not presented by respondent. I would also note that there was an increase in the number of days needed. First tardy request was for 14 more days, and that then went to 20, and then that went to 30. So that 15% was starting to require more and more days. And then I think someone said fell off the face of the earth. There was just no comment in the last of October, November, December, January. And the court took the initiative, the Court of Appeals did, of issuing a show cause order. The fact that the respondent asks for dismissal of this and says that she did nothing wrong, I think requires that her attention be gotten by the discipline this court imposes. And we would again ask you, as we did in the brief, to adopt the board's recommendation of a 6-month suspension. Are there any final questions? Thank you.
You. Court will take this matter under advisement.